Council, whenever you're ready.
Sorry, Judge, I was muted. Frank Cioli on behalf of Port Manatee. I was going to have more time, but I think Ms. LaQuasto, my study buddy to some degree for this, covered a number of the points. So I'm going to reserve 6 minutes for rebuttal. Basically, there was a lot of talk about.
I'm sorry, how much for rebuttal?
6 minutes, sorry.
Okay, all right.
There was a lot of discussion about the Langfit case in the appellee's brief, and actually we love Langfit, Judge, a panel, from a procedural standpoint. Langfit, it was a federal court case, but it was brought as Judge Kelly, as you point out, it was just a tort case. There was an affirmative defense raised for immunity, and guess what? Based on the affirmative defense, there was a motion for summary judgment. So the court basically went through a summary judgment analysis based on the affirmative defense. And, from the third page of Langfit, sentence begins, we begin with an explanation of the fact-dependent standard that our precedents have established for determining who was the employer in cases like Langfit's, where the answer is far from clear. So we actually love Langfit from a procedural standpoint because it basically fits the framework as as Judge Kelly pointed out, that if there's a claim that doesn't raise any sort of federal type issues, okay, then you raise an affirmative defense. And that's exactly what happened in Langfit, which is one of the most cited cases in the brief of the appellees. And it's also on all fours with a case called, I'm going to butcher this, Derogatis or Derogatis out of the second DCI. I believe Judge Kelly sat on that panel. That was a Florida work comp case, similar issue here. There was a borrowed servant issue as to whether or not the hospital was the employer. And the court said, no, these borrowed servant prongs are issues of material fact. So basically you've got Langfit out of the 11th Circuit covering Florida, and then you've got Derogatis out of the second DCA. So I feel like that's something that everyone's missed here. Even if he is a longshoreman, which we're saying he's not a longshoreman, that he's way beyond the twilight zone. Even if he is a longshoreman, let's figure out who his employer was first. I mean, I feel like everybody, the court just went, to longshoreman, but let's figure out whose employer he was first, and that's basically the Derogatis and the Langfit cases. And another point from Langfit that I think really needs to be highlighted is under Langfit. I'm going to quote from the first page. Every employer of covered employees, persons engaged in maritime employment, other person engaged in longshoring operations. The key part is every employer is the key part of the first sentence. Second clause, must secure and pay. That's from Langfit 11th Circuit. Must secure and pay the Act's compensation benefits. And then Langfit goes into a very pleasant analysis of the grand industrial bargain between the longshoremen and the longshoremen give up their rights to sue in tort if in exchange for getting paid compensation benefits. Well, here there's no grand bargain. We have Logistech basically saying, well, here's a piece of paper that says we have coverage, but the courthouses in Florida are full of cases that people thought they had coverage for something from hurricanes or whatnot, and as it turns out, they don't. So I think that the Langfit case says that in order to take advantage of the grand bargain, you have to pay. Velasquez got nothing from the bargain, and now he could be getting absolutely nothing. If this case is in reverse. So we believe Langfit case says that the benefits actually need to be paid. And just based on the Graham bargain, it seems like Velasquez is the one getting left out of this bargain. As far as whether or not he's a longshoreman, when the Longshore Act was amended, back in 1972, they had a big problem. What was the problem? They had people walking in and out of coverage every day. A guy was going on the ship, he's covered. Once he gets over onto land, he's not covered in it anymore. They said, wow, we could have an accident such as an explosion where a guy's sitting on land and a guy's sitting on the ship. They're both unloading the ship. They're both maritime employees, but one's going to be covered under state and one's going to be covered on longshore. That doesn't seem logical. So they said, let's extend longshore to the land, but just for these amphibious workers, not for any of the folks that are doing the land-based job, just for the amphibious workers. So they enacted the 1972 amendments to cover some of these land-based workers. Mr. Velasquez, as was pointed out, was working as a repacker of sorts. He was actually 2 steps removed from the process. What would happen was the longshoremen, the ILA guys, International Longshoremen Association guys, they would unload the vessel. They're trained to do that. Unload the vessel. They would put it right next to the ship. Then another set of longshoremen would take that and move that to the warehouse. So there's actually 2 steps removed here from Mr. Velasquez. And Mr. Velasquez, at that point, he was just getting that pallet and repacking the pallet to make sure some produce may have fallen off. This was a job for FreshQuest. There was some, produce may have fallen off. He's fixing the pallets and whatnot, getting it ready for its further transportation. So at that point, it's not point of rest. It's just the point that he's no longer an amphibious. The court, the Caputo court, and the congressional notes say amphibious employees. I don't think there's anything amphibious about what he was doing. He could have done that same job off of I-75. He could have done that same job in a warehouse off of 41. I think that the decision below in extending the Longshore Act to someone like like the plaintiff, Mr. Velasquez, actually is a radical departure from longshore law that really likes to keep these longshoremen at or near going on off the vessel. Or there's a case out there, I know that the appellee cited, where someone was fixing a loader that needed to go on off the vessel. Okay, I get it. That's an integral part of loading. He was fixing one of the yard mules that was going on off the vessel. But Mr. Velasquez's case here, he had no amphibious nature about him. Pre-1972, he would have been covered by by state comp, and it's our position that post-1972, he is covered by state comp also. And if that's actually because Ms. LaQuasto covered a number of my points. Those are essentially all the points I had. So if the court has no further questions, I'd like to reserve the rest of my time for rebuttal.
All right, sir. Thank you.
Thank you.
Mr. Dono.
Good morning again. I'm back. So in response to, I know the port says, well, let's first determine the borrowed servant case, who's let's scenario. Let's address that before we address preemption. I think it's the other way around. And I think that is what seems to be the crux of the case, is this matter really preempted? And there is a case that's been cited by I believe, in all briefs, and it's the Coley case versus Tri-State Marine. In that case, the action was initially filed in the Florida State Court. And the reason I know that is because my firm had handled that case, and we filed an almost identical motion to dismiss. Obviously, the facts were a little bit different in that case, but it was premised on the same analysis, that the act preempted and divested the Florida State Courts of jurisdiction. The court agreed and dismissed the action, and the action was then refiled in federal court. There, the court addressed the issue of the employee status because it's a federal court and it had jurisdiction. So that is the same scenario we have here, where a longshoreman, somebody who is covered under the act, has filed a tort claim, and the court recognized that, went through an evidentiary hearing, and determined that ultimately it had no subject matter jurisdiction. Why? Because the act is preemptive. Once it's determined that there's a borrowed servant relationship, which the court did, it went through all the factors, all the Langfit analysis. It almost went beyond where it was supposed to go. It could have done it on affidavits. It could have done it on other evidence. It decided to hold an evidentiary hearing to make sure that the facts in this case supported that, number one, he was a borrowed servant, and number two, that he was a person who qualified as a longshoreman under the act. Depositions were taken, evidence was submitted to the court, and this evidentiary hearing was held. And if you look at the court's order, it's detailed. There's no question, there's no issues of fact here. This person is a person who's covered under the act, and because he is covered under the act, he is precluded. The court does not have subject matter jurisdiction. If the Supreme Court has recognized that the ability to sue an employer is precluded, the act is in fact preclusive. Where liability, and I believe it's in the Hetzel case, Hetzel versus Bethlehem Steel, 50 F 3rd 360, the court there held where liability arises as a result of the employment relationship. Congress explicitly intended for the Longshore Harbor Workers Compensation Act to be the exclusive remedy. It's not, it didn't say you can go ahead and file a claim in state court. No, once the act is found to apply, you cannot bring a tort claim, especially in state court. So he should now file in federal court. Shives versus CSX Transport. There, the court held state courts do not have jurisdiction over longshore harbor worker compensation cases. So the clear and express language of 905A, which is the Longshore Harbor Workers Compensation Act, provides a liability under the act again. And to quote it, says, shall be exclusive and in place of all other liability to the employee against his statutorily defined employer. So the court here recognized that and then went through a proper evidentiary proceeding, which is what the court has held in Boca Berger versus Forum, the Florida Supreme Court, where it said where there's an issue of federal preemption, that is a question of subject matter jurisdiction. And the lack of subject matter jurisdiction may be properly asserted in a motion to dismiss. And then you have the Trammell case that says you do not need to be bound by the four corners. When it's an issue of subject matter jurisdiction, at a motion to dismiss, the court can hear evidence and determine its power to entertain this cause of action. That's what the court here did. Now, I also heard about, we need to pay, I think it's pay compensation, if I understood correctly, for the act, for the Longshore Harbor Workers Act to be applicable. And that's simply not true. The statute 33 USC code Section 904, liability for compensation, says every employer shall be liable for and shall secure the payment to his employees of compensation payable under sections 907, and it continues. But you have to just merely secure the payment. And there's various legal authorities cited in our brief which make that clear. And that is the Birkenbach versus National Gypsum case. There, the court went through that same analysis and lays out the fact that, and it says, it held that an employer has the potential to pay, and that's all that's required, when either obtaining and maintaining an insurance policy, which was moved into the record at the evidentiary hearing, the Signal Mutual declaration page, which shows there was Longshore Harbor workers' compensation coverage. And then there's another method of accomplishing that, which doesn't apply here, which is to furnish the Secretary of Labor with a satisfactory proof of the employer's financial ability to pay. That was not necessary here because we secured a policy of insurance. Then the next thing
Well, let me just stop you there. You had the policy of insurance. Did you concede, acknowledge that he would be covered under that?
Yes, there was a corporate representative who was deposed. It was Mr. Carrigan, and he testified, and that was submitted as evidence at the evidentiary hearing, that in fact the Signal Mutual policy would cover Velasquez for his injury. So the other issue seems to be the downplay of what he was doing at the port. It doesn't have to be. I think I heard the term aquatic. It doesn't. That's not the test. If you look at the Atlantic case, in that case it was a person who wasn't unloading or handling cargo as it was coming off the ship. The only thing this individual was doing was repairing the containers. If a handle was broken on the container, he would repair that. If there was a tire that was broken on a carrier, he would repair the tire. He would change the tire. He was doing that type of work, which, again, that could be accomplished outside of a port environment. This individual was still found to have met the test for Longshore Harbor. The test isn't whether it's aquatic or not. It's whether you are participating in some manner in the loading and unloading of the ship, which there's no doubt, and there was no doubt to the court, who for hours heard the evidence that Velasquez was in fact a person who was covered under the act. He was integral to the process of loading and of unloading the ship, and that was set forth in the testimony of several logistic employees, his supervisors, people who worked with him there at the port, and explained his responsibilities. Now, the other thing is, in their reply brief, it seemed to me that at all points at the trial court level and at the and in their initial brief, that the test that the port had been arguing as to borrowed servants was the Ruiz test, which has now been incorporated into Langfit. And now for the first time, I saw in the reply brief the port arguing for almost the application of Florida law with respect to the borrowed servant doctrine. Now, as the court knows, an issue cannot be raised for the first time in a reply brief, so that argument has been waived. But regardless, and I think the reason it's now being raised in reply is almost it may be a test that may be more favorable to the plaintiff, but that's not the test that applies. It's clear that the test that applies is Langfit. That's the test that courts apply when determining whether there is a borrowed servant relationship under the Longshore Harbor Workers' Compensation Act, because it's a different situation working at a port than it is maybe working and a hospital. So that's why the 11th Circuit crafted this case that was specific to the Longshore Harbor Workers' Compensation Act cases. Now, if the court has no other questions, Logistic rests on its brief.
Right, thank you, sir. All right, Mr. Scioli.
Thank you, Judge. Just a few points with respect to the, there was Judge Kelly, you had a question as to whether or not the insurance was conceded. And yeah, they had a rep from their company say that, that he thought that there was coverage and they had this policy. But he admitted in his testimony that, as was brought up earlier in my argument, that there had been no communication with the carrier, and it's really up to the carrier under the Longshore Act. You secure benefits through an insurance carrier, so it's really up to the carrier to say whether or not there's actually coverage, and not the actual employer themselves interpreting the insurance company's contract. Second, with regard to the comments on the integral, it's true. I mean, there was testimony that his jobs were an integral part of the loading, but testimony can't overrule the congressional intent in the Supreme Court in the case of them interpret the act. If there was testimony in this case that said, oh, well, the testimony in this case, one of the witnesses said that, oh, it's not being finished unloading until it gets to the end customer. All right, so when it gets now it goes from Fresh Quest on an 18-wheeler to the Publix warehouse in a Lakeland, and someone's unloading the produce there. Let's just say they're the final customer, not the person actually at Publix, because maybe they're the final customer. So, someone's testimony can't be used to stretch the law that Congress said was supposed to just cover longshoremen. So that's our point with that. And as previously noted, the whether you use Langford, whether you use the second DCA opinions that we cited in our reply brief that we believe were properly cited, but if you don't want to use the second DCA, use a Langford. I mean, they basically say the same thing, and everyone here cited Langford. Is that the borrowed servant factors are issues of fact for the court, for the jury to determine. And if there's no there was one point I wanted to make about Trammell. Trammell, that was brought up in the response. Trammell was a case where they actually alleged in the complaint itself, I think they called it a declaration back then, but it was alleged in the declaration that there was employer-employee relationship, and that's what took it out on its face. So that's entirely different from the situation here. So there's a very exacting standard for preemption in this state. This state favors giving these cases to the jury, and that's our position. And if there's no further question, that's all I have.
Okay, thank you, sir. Thank you both.
Thank you, Judge.
Okay, our next case this morning is the Roundup versus Diamond Horseshoe Holdings.